We'll go ahead and call this meeting of the Rules, Charter Review, Ethics, and Council Operations Committee meeting to order, focusing on ethics. I'll appoint this meeting, as we have in the past, Councilmember Brady as secretary, and Mr. Nani will be the recording secretary.
Thanks. Calling the roll, Dale Miller. Connolly. Dan Brady. Present. Dave Greenspan. And Sonny Simon is not here at the present time.
The next item is to approval of minutes from our last meeting. We're going fast and furious right now, so we've got draft minutes and we will have those minutes available at our next meeting for approval. Moving on to open issues, old business. The definitions that we've been working on for the last two meetings are now before us. Mr. Nani has been putting them together. They're about 85% or so is what he's telling me complete. What we'll do, and let me kind of give an overview as to today's proceedings and where we're going to head with this. I will take these definitions and incorporate them into the document that you have before you for our next meeting, and actually I'll get that to you before our next meeting. And let me apologize for not having the draft ethics ordinance through sections 1 through 4 to you before today. I was up till 9:30 last night getting these compiled, working. Joe and I worked Friday afternoon. I worked all day Saturday and Sunday getting these together. So we'd have this today so that we can talk about some actual policy decisions or policy direction in the ethics ordinance.
Mr. Greenspan, point of order. Did you do that during the Steelers game last night?
I have a TV in my office, so I was watching both games. So what we'll do, let me explain to you the process I've gone through thus far and to give us a little leg up on the overall process and what we're trying to do. Initially, my focus was to work with the committee on coming up with the definitions so we can cohesively come together and put these together. We've done that. So that we are consistent in what the materials we're looking at, I have compiled the 4 sources of reference materials that we talked about: the Ohio Revised Code, the Transition Advisory Group document, the county ethics policies, in addition to the state ethics ordinances, and then the document that I put together previously. What I did is, and if you look at this document that has the, it has, well, they both have draft on it. This one has a gray margin off to the right, which has the changes, and I used the track changes feature. What I did was I went through the various 4 documents, and I looked for sections that, and actually Councilmember Miller was very helpful in providing me with a sample of a topics list, which I've converted most of that into the table of contents. So, for example, where we found a topic such as misuse of official position under prohibited conduct, I went through and looked at the 4 source documents, compiled that topic under one heading, put those on this one document, and then went through and made recommendations for us to consider as a possible section for the ordinance. And that was the step I made throughout the whole process. We went through, I went through, I should say, the preamble, general provisions, prohibited conduct, and then conflicts of interest sections of the various ordinances. There's more work to be done, and I will continue to move forward to do that. The other items that we will talk about, I'll use Mr. Miller's draft here, will be the disclosure and transparency, the ethics board, which I want to talk about today. There's some financial consideration or financial disclosure items which are in state law, which I believe would be prudent for us to include in our ordinance, and any other provisions such as the whistleblower provisions and things like that. I'll have those for us next week. Even if I was to have those today, there's so much for us to go through today, we wouldn't have gotten through it all anyhow. So I believe we're moving right along our plan in order to have everything done into the State Ohio Ethics Commission by the end of the first week in February for review and their approval, or not their approval, but their feedback by February 17th, which will give us just enough time to get it in for first reading to meet our March 22nd deadline. So what I've done, and I mentioned this, and we'll look at, if everybody would turn to page 5 in this. Well, let me, before I go there, we have 2 sets of documents. You've got one that looks like it's clean, a clean version, and you have one that's marked up. That's exactly what it is. You've got one as if we had accepted all the changes, and we have one that shows how everything was compiled and what was added or changed to the previously referenced materials. Does everybody follow? Correct. So Dan, so the copy on your left, why don't we work from the copy that has the changes? The copy on the right would be a clean document, as if those changes were accepted. So we'll just start right off with, and this won't, I don't believe this will be as an arduous process until we get into some items under general discussion. I know some of you have comments and items you want to bring forward for discussion, but I think it'd be prudent if we walk through at least the various sections right now in the preamble. In the 4 sections, 4 articles, starting with the preamble. And I'll just go ahead and start with, and let me apologize, I wanted to get this to you before today. I don't like the fact that you're seeing it for the first time, but time being what it is, unfortunately, I would just ask for your indulgence as we move through this. What I've done is taken in the preamble the only 2 documents that I found, I'm sorry, I take it back. There are 3 documents that I found that had any type of reference to a preamble, i.e. what is it we want to accomplish here. We had the Transition Advisory Group, we had the current county ethics policy had a statement at the beginning, and then we had one that I had presented, which came off of an ordinance down in Georgia. Mr. Miller made reference that he liked the wording, I believe, of the language from the ordinance brought forward, that I brought forward, and that was the tack that I took in at least shaping the preamble. And if there are any questions, obviously I know you want to read it. I tried to change where I could to make it more consistent throughout the document with some of the terminology and definitions that we used, that we agreed to, at least from my memory, since the definitions were a work in process over the weekend. Are there any questions or discussion about this? Right. Yes. And what will happen is today, Mr. Nani will actually, he has this document electronically and will transcribe right into the record any changes we make.
Mr. Chairman.
Mr. Brady.
I don't have any objections to the preamble, but just a general question. I don't have any opposition to breaking new ground in terms of how we conduct our business and what we do. But is there some precedence for such a preamble before as a lead into an ethics bill that we could point to for not just guidance, but is there?
Is this customary? Is that?
Yes, is this customary? Yeah.
The Transition Advisory Group felt it was customary to have something. I know the ordinance I brought forward out of Georgia had some type of language in the beginning. It wasn't called a preamble. It was actually called a declaration of policy. But something to at least set the tone as to what this document was to cover, and the flavor or the culture that we wanted to instill.
And all this is going to be reviewed by the Ohio Ethics Commission.
Absolutely. Actually, before it goes there, it'll be reviewed. It'll be reviewed by our attorney, the director of law, then sent to the Ohio Ethics Commission.
Thank you, Mr.
Yes,
Chairman.
Sir. Mr. Miller.
I just think, especially seeing things like this, for the first time, at least in terms of what choices have been made. It's not always going to be easy to make decisions about these things on the fly. You know, I think we're going to need an opportunity to take this home, to look at it, and if we have suggestions, to bring them back at a future meeting, as opposed to well, we have to make a decision today on a section.
Yeah, and I agree, and I do apologize that we met on Thursday. We wanted to meet as quickly as possible to get this through, and I tried to get this together as quickly as I could. Understanding also that we will have multiple. We've got another meeting. We'll talk at the end, which will be next week, which will give us an opportunity to do that. Hopefully, get you my goal is to get you this same type of material to you in advance of the meeting. And but I think it would be wise, at least right now, to understand through the items that are presented, where are we? Some of these are very explicit; they're just state law as they are stated. And I'd like for us to at least go through the exercise of understanding where we are. Yes,
Mr. Chairman, I just like to say, my experience has been that it's not that uncommon in front of that they have not had about that being changed. Remember, okay, all right. Excuse me, ladies. But in this situation, where we're talking about an ethics bill, I think that it's going to be necessary to, really be able to digest a lot of this information more thoroughly. Lots of times legislation is marked up late in the game, amended late in the game, and so it goes through so many revisions that it's pretty hard to spell it all out way in advance, because it's changed by the time it gets to the next step. But this in particular, I think is a little bit different. But I'm comfortable with the fact that you've got a lot of sort of gateways that you're going to go through in order to make sure that it's properly vetted.
Well, I mean, I actually, and thank you for those comments, I actually considered, because the information was presented to you so late, postponing this meeting. However, we were outside of the time frame in order to do so. So I wanted to at least come together and see what we could address, what we couldn't. And I'm not adverse to moving through this and seeing where we are. I'm also not adverse if we wanted to move this to the next meeting after people have had an opportunity to review it. Just wanted to get kind of a general consensus. And maybe we'll walk through a couple of these, like on this document, this specific section, because it's so long and it's so encompassing. We may decide that this is something we want to discuss and bring back next week, and I'm fine with that. At the same token, there may be an opportunity for us to at least identify some items that we're in agreement on. Some there's not a lot of discussion, that I can tell you. But let me ask you this, and I'll be glad to table the discussion of these specific items until next Tuesday, if that's helpful to the committee. I'm not adverse to that at all.
Mr. Chairman, it's up to you how you want to proceed, of course. I would be... You had said that before this would be sent down to the Ohio Ethics Commission, our own attorney would also review it. Is it possible that we could have our attorney review this and look for problems that I, as someone who's not an attorney, might not find anyway, even if I did read it, so that that when it comes in front of me, at least I know it's that it's been professionally sort of cleared as a document for consideration by someone who's been trained to do that.
Yeah, we could do that. I always find in dealing in general with attorneys that it's best for us to guide them versus them guide us.
I don't want to be.
I understand.
I don't want to be. I don't. Yeah. I don't want to be guided. I just don't want to. I just want to be as informed as I can.
Sure.
I'm used to a lot of attorneys looking over legislation before it's in front of me. Most legislators are not attorneys, contrary to popular view, and but they certainly need the assistance of.
Well, that's fair. And oh yeah, Sonny's sorry, I didn't mean to make that attorney comment. We can go ahead, and I'm okay with moving this, tabling the discussion on these items so that committees had an opportunity to review it, and in the interim, I can present it to Mr. Morales for his review, which is what I intended to do anyhow. Like I said, we just met Thursday afternoon. I wanted to make sure that we stayed on a schedule to meet our deadline. But Mr. Miller, yes.
Returning to the discussion about the preamble. I think it's important to have something like this in the document. I'm aware of some court cases basically involving the Sunshine Law in which some courts have opined that it would be good if the minutes of meetings would contain statements of the rationale why actions were taken. And I actually think that it would be better yet for the rationale to be stated right in the legislation itself, because the legislation is hopefully prepared by the legislators, and if you leave it to be put in the minutes, typically the minutes have to be prepared by others who would be trying to interpret what the rationale was of the legislators. So I think it's good to have something like this in the document, and I think we should give some pretty careful thought as to how actually it should read. So I think what we have here is certainly a start, but I think we should continue to work on it.
I don't have any opposition at all to moving the discussion to these these first four articles until next Tuesday to give the board and the attorney an opportunity to review it. I don't have an issue there. As I said, I was thinking about postponing this meeting to give just that opportunity. So if there's no objection to that, I'm not opposed to doing that at all. It may mean that we might have to double up some meetings in the coming weeks in order to meet the deadlines that we statutorily have to meet. And that'll give you an opportunity to review this. Let me just gain a consensus here. Me compiling it in this fashion, is this amenable? My initial content or purpose was we'd lay out the four documents and we collectively work through which provisions of each we wanted to. That we wanted to discuss. I don't have an issue at all taking the lead in proposing the legislation and discussing any changes thereafter, if that's the avenue we want to go down. And I'm perfectly fine with doing that.
I think that would be, for this councilman, that would be a preferred way to go about it. For it's your legislation, and for you to put it in front of us, and then as a committee for us to discuss it and see where we go with it. I guess my intuition or compulsion is to be looking for where the policy issues are and where the discussion that legislators have is going to occur, and have make sure that on the more overarching issues that are going to be discussed, that there's consensus in the direction that we're going.
Okay, that's fair. That's fair. Then if there's no objection, I'll go ahead and compile as I've done, so you can see what the methodology was. Present it to you in advance of the meeting, as I intended to do, and then at the meeting you give me your feedback on the legislation that's proposed.
Mr. Chair, First, I apologize for missing last Thursday's meeting. My car battery died on the way back from Geauga County, and so it was difficult to get here. So I just want to make sure I understand that the document in front of me is the Ethics Code, a draft indicating Cuyahoga County is what document are you talking about submitting to us?
It'll be that document. Well, there should be another one there that's kind of redlined, but that's the document that what I've done is compiled the various sources we agreed to in our first meeting into one document by subject. So you can see each of the different stakeholders and how they define a specific topic. And then I've gone through and made recommendations as to which we should move forward as to be part of the ordinance. So you have a clean copy as to what it would look like if it was a final version, if everything was adopted as I proposed. And then you've got a marked up copy that shows what the considerations were.
And this only went so far as definitions, or did you?
This one, the first four articles, as you see in the table of contents, it actually addresses those issues. Definitions will be incorporated in there. We just got those today. We're just trying that, once again, we're moving quickly so that we can meet the deadline, not hastily, but just quickly through the process. So if that's the direction, I'm fine with that. And next Tuesday when we meet, we will go through in more detail after you've had an opportunity to review it. There are still, however, some policy discussions, and I've asked each of you to come up with some suggestions. I see Mr. Miller has some, which I'll need some guidance in order to compile this. The first one that I'd like to bring forward would be the discussion of the role of the ethics policy as it relates to having an ethics board or allowing the ethics board to be under the purview, if at all existent or required, of the Inspector General.
No, Mr. Chair, I understand under the suggestion or the proposal offered by the Transition Committee, there was a whole, and a bureaucracy maybe is the wrong word, but there was an ethics commissioner and then a commission set forth under that, which would, cost some money because we have to hire the commissioner and staff and some other persons. And then parallel to that, now we've already started this, we're going to have the Inspector General. My feeling is that to have that ethics commission would be a duplicity. And, to spend that additional funds, plus we have the whole personnel procedure. So my inclination at this point would be to hold up on having another bureaucracy set up just because we already have something with the Inspector General.
And I appreciate that. I was going to call on this topic Linda Mayer, who was chair of the Transition Advisory Group, to come forward if she would and explain. And I know, having talked with Ms. Mayer, that when they put the proposal together, the IG wasn't really even in the picture. So if you could go through the rationale and the process with the ethics board as it related to the to your proposal.
Okay, I could explain to you that we put off the question of an ethics board until we had completed the provisions that we wanted to be in the code, because we thought maybe we don't need a board, even though we read 14 other comparable county ethics codes in order to find out what the other counties did that were from counties similar to ours. And there was only one of the 14 that did not have an ethics board. So every county that has our kind of county government structure and our kind of size politically, et cetera, they all but one, and that was Colorado Springs. That's El Paso County, Colorado. They don't have an ethics board. Everybody else has one. Now, that's not, any parent knows that's not a good excuse for setting policy. However, we wanted to see what additional things were in our code that would need local enforcement. Because if everything is simply state law, then we have a state ethics board, and we don't need a local one. But we found that we had added on a lot of things that were not in state law. And so there was no possibility to enforce them unless we had a board to enforce them. And a certain modest type of due process set up to deal with violations of county law, because there was nobody to enforce them. We didn't, as you mentioned, we didn't know about the Inspector General proposal. But the big thing that we thought was the most important, other than we need some enforcement of county civil law with civil penalties right within the county itself. You don't have to go outside into criminal court to get these kinds of sanctions. But we felt that above all, this ethics board, or whatever you call it, has got to be independent, because it's going to be enforcing ethics policy across the county bureaucracy, some of which is controlled, not that much, by the council, most of which is controlled by the county executive now. But we also wanted it to apply in the prosecutor's office and in some of the boards and commissions. So we saw no way to enforce our code unless there was an ethics board, and it has to be independent because the person who is doing the enforcing, the main legal officer, whatever you call him or her, that person should not be answerable for continued employment to the person in charge of the bureaucracy that she or he is in charge of watchdogging. The political process had to be taken out of ethics enforcement. So there's a reason for having an ethics board and a reason for having it be independent. And I do not see in your reasoning, I don't see that there's any enforcement, any teeth to a code that you write if there's no board. But maybe you can think of something other than a board. And I don't see how you can enforce it with a partisan political appointee.
Mr. Chairman.
Mr. Brady.
Mr. Chairman, I think that this conversation, at least for me, is most helpful because it seems like that right at the center, of this whole discussion, we can follow state law for our ethics. We can enhance state law if we want, but right at the center of this whole discussion is really the whether or not, and that's an interesting discussion, whether we have an ethics board, and also the proposal that not just the proposal, but the intention of the county executive to have an inspector general, and it seems like we've really got to have that discussion, because we're going to get to it eventually anyway. And it seems like, there'll be, once we know whether we're going to even consider an ethics board or not, then if we are going to consider it, go down that road and begin to consider it. And if we decide to do it, then what's it going to look like and how is it going to operate? Those questions, in my mind, need to be settled at the beginning of this process, and not waiting to be discussed down the road, because if we decide not to have an ethics board, then we're going to be doing, it's going to influence exactly, what we're going to be doing here. I know that the chairman, and I'm sorry to please indulge me for this amount of time, I know that the chairman has indicated an interest in an inspector general, and I think may have some ideas that are unique and independent of what the county executive has in mind. And these are really the big policy issues here as I see them. And I'd like to hear some feedback
Here's what
about
you
that.
can't do. If you don't appoint a board, and if you go with the inspector general only, who might have some staff, if you go with that system only, you've got you can't enforce anything that's not state law. because the IG would forward. I think the IG could do three things. The IG could forward complaints to the state ethics board. The IG could give advice, and the IG could, let's see, I thought this out coming in the car. The IG could also, it's one other thing. Okay, sorry, it escaped. So if you don't add anything onto state law, I think you can get away with no ethics board. Okay, but if you add things in, I think you have to add enforcement in, or else what's the point? No teeth.
Real quick, and then Ms. Conley and then Mr. Miller. In these 14, this just may be helpful, in the 14 communities you studied, counties you studied, 13 had ethics boards. Did any of those have any form of local county inspector general office?
One county called it the ombudsman. One county called it the law director. One county called it the inspector general. Most of them called it ethics officer. We just picked a generic term.
Conley?
Okay, if you have this ethics officer and this ethics commission, are you giving them prosecutorial powers or what? I don't understand what what this board could do.
Well, the board that we conceptualized has more function than just enforcement. But there is a due process piece. I'm sure you've read it by now in our recommendation, and it's a due process which we adapted from the Code of Allegheny County in Pennsylvania.
So does this commission have investigatory powers
Yes.
and then prosecutorial powers?
Yes, only on the add-ons and only in civil matters. Wherever county law exceeds state law, they have that power to investigate.
They could then conduct a hearing
Yes.
and issue some civil sanctions, monetary
Yes.
and disciplinary sanctions?
Yes.
And how many people would you envision this commission involving, and how would they get on the commission? So would they be volunteers, would they be paid? I know if we have an officer, that person would have to be paid and have a staff.
Well, the board itself, in our proposal, the board itself is unpaid, and there's a process by which civic organizations, this idea was adapted from Milwaukee County in Wisconsin, and civic groups would be requested to submit names to the county executive, and the county executive would have to choose nominees from the submitted names, and then the council would approve them. So that was how we came up with a 5-person ethics board, because we liked that idea that they used we thought the best practice in the country was the one in Milwaukee. However, there were the other types of the other mechanisms for accomplishing independence mostly were bipartisan. They were the Democrats give you some names and the Republicans give you some names, and you have a board of 5, and no more than 3 can be from the same party. And then they have to be confirmed by council. And that's the way most of them worked. We just thought the one in Milwaukee was more innovative. So that would be your call. But one thing I want to say before I sit down is that we envision the board having really a 3-pronged role, not just administering due process on complaints, but the whole education role for educating all the covered persons. And we expanded the amount of covered persons quite a bit from what would narrowly be considered county employees. And then the third one is extensive record keeping, so that searches and registries could be cross-referenced and you could really track where the money goes through the system that we envisioned. It's called one-stop transparency, and it requires some technological expertise on an ethics board staff.
Mr. Miller? Oh, I'm sorry.
Yeah.
I mean, Mr. Miller?
Mr. Chairman, Ms. Mayor, first I would mention that your report also advocated a fourth function, which would be providing advisory opinions.
We purposefully avoided the word advisory opinions because that's a word that, if you look at state ethics law, you folks are reading the statutes, but there's a huge body of case law and a huge body of advisory opinions, which also have the same effect as generally applicable law. And so in order to, for example, on nepotism and patronage, if you look at the statute, it looks very bland, and you can't tell that it's against nepotism, but the way you can tell is by reading the advisory opinions and by reading the case law. And suddenly you realize that it's been interpreted that way. So therefore well, I'm not sure I'm answering your question, though.
Mr. Chairman, I did have one specific question, which is that if in our ethics law we basically restate the state law as part of it and include the state law.
That was a decision that our worker reached after, and we had lots of back and forth on that. But we decided to do that. We wanted the people who are covered by this to be able to look in one place and find it, and not have to look in 2 or 3 different places.
Well, Ms. Mayor, I'm in the same place. My question is, if we do that, then can the ethics board deal with complaints involving state law violations, or do those still have to be sent down to Columbus to the Ohio Ethics Board?
Well, you folks may think of a better thing than we thought of, but we thought that we should leave. We talked a lot with David Friel of the Ohio Ethics Commission, and he wanted to continue to receive complaints on state law. And so we thought, and he didn't relish having competing jurisdictions on state law. He didn't want our local ethics board to be adjudicating stuff that's in state law that he has the mandate to enforce himself. So we compromised there, and our proposal says that the local officer, who by whatever name, the local officer forwards things, okay? Forwards criminal complaints and also complaints of state or federal law. Federal can be, I mean, think of sexual harassment, think of discrimination complaints. Those have to go to the U.S. attorney. So it's not all of it gets forwarded to state. But we decided that our enforcement body should just take care of county law and civil.
Thank you. Ms. Simon, did you have a comment?
Thank you very much for giving us your insight in the work you've done. It's comprehensive.
The reason we come all the time is that we hope we'll get asked, because we did all this stuff to help you guys, because this is a huge thing. It took us 6 months, and you're going to try to do it in 3 or 4 weeks.
Mr. Chairman.
We don't know how you can do that, but yeah.
Mr. Chairman, I personally, I'd like to take up as much time as Linda would give us. It is Linda, isn't it? I'm sorry, I'm just making sure, Mr. Chairman.
Please.
You know what you've just said, Mr. Chairman. You know, about whether or not we have sufficient time, which you don't seem to think we may not have. That's a fundamental question. There's so many kind of threshold questions here. I don't, I think we need to get at. You said you looked at several models, 15 to 20 different models that had ethics boards, and I'm wondering, Mr. Chairman, to Mrs. Mayor, that did you look just at the structure, how they're set up, or did you look at their track record in terms of what came before them and how those issues were resolved and what kind of success they had, regardless of their structure?
We read codes, and we actually, Mrs. Dunbar and I and Mrs. Barlow, the three of us went to Allegheny County, and we sat for an afternoon with their equivalent of law director, who was acted as counsel for their ethics board, and the head of their ethics board, and their administrator of their program, and so with them we went in depth, and we looked at what they did, what they undertook, what we thought was their effectiveness, etc. And we decided that we liked some things about them, and we didn't like some other things about them, and we brought them back and batted around the ideas and decided to propose a lot of the skeleton outline of how they do things, but to change several things because we think their enforcement is weak.
Okay. Ms. Simon.
Mr. Chair, I appreciate everything.
I'm happy to go
good.
sit down.
I don't think you need to sit down,
I'll come
but I
back.
think our process might involve seeing exactly where we stand with regard to the state ethics code and what we're going to adopt. And if we do adopt and go further significantly, that would require us or perhaps invite us into looking at an ethics board. Maybe that, instead of it's what comes first. If we're going to stick with the state, they're very equipped and experienced and to enforce and educate. My concern is that if we get these appointees on this board who don't have experience or are as experienced as the state ethics board, which, as our president has talked about, having them come up and train, that it will be not as strong with the experience. So from my standpoint, I'm looking at that aspect.
Okay. They have 22 employees. Their jurisdiction is every political subdivision in the state of Ohio, including all school boards, all boards and commissions, and the entire executive branch bureaucracy of state government. If you add all that together and see what they cover and what they have to try to educate and yes, we should use them, their materials, they have great materials, but they're stretched and their budget is cut every year. And we think that the things that happened in Cuyahoga County, to some extent, you have to say it happened on their watch. They were in charge here over the years that our county went astray. And so we lay that partly at their door. And if I said this to the rest of the members of the work group, some of them would be jumping up and down, protesting at what you say. We need a board of clean-thinking, independent citizens, and then we need a good enforcement person with a good code to enforce.
I just have to say that this code, I think, should be interpreted. I mean, if we're really going to empower a board of citizens to bring perhaps criminal or civil infractions with penalty, I fear that without experience of interpreting the ethics code as much as this, and I totally understand that they're understaffed, but we're going to have an IG now that I think if we had one prior to, before, I'm not sure that we could have had the corruption as we did here in the county. But those are just my concerns, that a group of citizens are going to be interpreting and perhaps subjecting people to civil penalties without the experience of interpreting and understanding these codes. I mean, I think there's some legal background that would be helpful with that.
Well, I would expect that if you put together a code of five upstanding capable people who didn't have ethics experience, you would want to train them. You would want to have the Ohio board come in and give them a good orientation course on what they should be doing. But basically what they're doing is appointing whether they appoint the IG or whether they have to appoint somebody who does the legal work, because they will not be legally qualified people.
That's why I wonder if we need the board. It seems like a middle board when the IG can go directly to the it's just, I'm just thinking out loud. I understand.
When you folks prepare yourself for your next meetings and read that thing that Dave worked on over the whole weekend, you must have had a terrible weekend. Do read
he likes this.
Do read Article 5, because Article 5 taken together shows you what we think an ethics board needs to do, and it doesn't all require it. It requires dedicated people. It doesn't require experts.
Yeah, thank you, Ms. Mayor. Let me start by saying when originally, and I'll speak solely from experience. When we formed this back in Atlanta, we had a 5-person ethics board. We did not have an inspector general. Our composition, we were nonpartisan. Our composition were basically 5 appointees from the mayor, or from, in this case, the executive. Political party was an issue because it was nonpartisan. And they met, and they made recommendations. It was a citizen committee. When I put together the ethics proposal that I suggested, I followed that same protocol, although there was a partisan aspect to it here because it was a partisan environment, 3 and 2, as Ms. Mayor said, in some of the other environments that she's seen. Now that we have, and I've come off my position on that, and have focused on the Inspector General, the Office of the Inspector General. So it's not just one person. This Inspector General will have a staff, much like the ethics officer that you talked about in your ordinance. But the Inspector General is, all right, here's how I'll just speak candidly how I envision this. We passed an ethics ordinance that has the rules and policies of the county, and the Inspector General is the investigative authority to the ethics ordinance itself. The determination is made based on, depending on the infraction, where it goes. And Ms. Mayor's correct. It might be a federal infraction. It might be an internal infraction within the county. There's no prosecutory actions necessary, merely a reprimand to the employee who violated the ethics law. So that would be handled by the executive and the department head. And it ranges the gamut of everything in between. But, and I like the idea of having professionals, i.e. the Inspector General and his or her, well, in this case, and her staff, to do the investigations and conduct the necessary subpoena. They have subpoena power. They can do everything they need to do. We're going to have this office as part of our government corporate structure. And so, and I believe in my preliminary discussions with Mr. Fitzgerald, it's his vision as well that the IG would be the investigative arm for enforcing the ethics policy.
Does he plan to put that into to propose it to become a charter position?
Well, and that's something that he and I are meeting next week. I believe it's time to check.
Because right now that office that he has created has no basis and it's not established by anything. It's his choice. Correct. In his administration.
And as this board is aware, I presented an Inspector General ordinance as well. And in that ordinance does require a charter change to make that office, let's say the department head, the Inspector General, completely independent. And in preliminary conversations with Mr. Fitzgerald, he agrees that it needs to be independent in some structure. He and I just haven't met yet to discuss what that structure might be. The structure that I proposed in my Inspector General ordinance would be an independent 5-person body, primarily composed of non-Cuyahoga County residents, would select, hire, and fire the Inspector General, but also serve as the review board.
Well,
in order to make it independent.
Why residents? I'm just wondering why.
Well,
residents not from Cuyahoga County.
Well, my recommendation was that it be a delegate or the state Inspector General, the state auditor, or his designee, the office's designee, a representative from the state bar, the state society of CPAs, and then the county prosecutor would serve as the elected official on that selection and oversight board. So that way, the whole intent of the Inspector General is to be free from input or influence from anything going on within the county.
Well, Mr. Chairman,
And that could be another, obviously this group will talk about the Inspector General later. You know, it's another ordinance that we would need to propose.
I guess that's the point, Mr. Chairman. It's sort of a chicken and egg discussion that I admit I can't figure out where the chicken and where the egg is. You know, I really can't. I would envision Inspector General having to be an independent institution for it to make any sense at all. If it's just simply an appointee of the executive, then I don't get it. But you know, the difference between that and anybody else that the executive appoints to a position, and yet we're in a position we also have the executive appointing sheriffs and other positions that are quite unique for people to have that kind of authority to. So I really am looking for not knowing where to begin the discussion. We have a lot of work that's been done around the possibility of an ethics board, which seems more like a civilian kind of an oversight, and then we have this sort of a police, more of a authority approach of someone with the power and the background, you would presume, to have a position like this, and yet are they independent or not? Could someone be appointed to a position where they had independence for a certain term by the executive, and the executive not have the authority to remove them during the course of their term? Therefore, they would be independent the way the FBI director is independent in Washington and other people are independent. I know we're sort of, almost, jamming here in terms of the way we're discussing this, but it does seem like there are just some really big issues here that we're going to have some kind of a consensus on before we do anything significant other than just review state law and enhance parts of it.
Well, and that's why I brought it up, because you're right, it is important for us to understand. The question, I guess my question is, as this ordinance gets crafted, where do we want the investigative authority to be? With the board or with the Inspector General? And then obviously the questions come up with the valid questions.
You have to combine them. I think you have to combine them.
Well, my concern is they would duplicate. Where does one start and the other stop?
Well, for one thing, I've read the description that Mr. Fitzgerald envisions to be the role of the Inspector General, and it goes beyond enforcing ethics law. In fact, it's only in the last month that he's said anything about that being the ethics enforcement officer. He wants forensic accounting, that
right.
kind of thing.
In the Florida Inspector General ordinance that I studied coming up with my proposal, the Inspector General's office. Now it's the office. It's not one person. It's an office. They have multiple functions. They are the ethics enforcement division. So let's use that word instead of that. They're the ethics enforcement division. They are also effectively an independent efficiency study organization, the forensic that you're speaking of. And the final thing is they focus on the reduction of wasteful spending in an independent fashion. So those are the three primary functions.
Reduction of wasteful spending has nothing to do with ethics.
No, but the office, I'm just telling you what how the Florida law reads, and those are the three delineating categories of responsibility.
Perhaps the best code we ever read was the one from Duval County, Florida. Mm-hmm. We picked off the most interesting items from that code, more than from other codes. So I'm not sure. We read about 3 codes from Florida, but that one stood out as being outstanding. Just before I go sit down, just keep in mind that there's more for an ethics board to do than just process complaints and do investigations. Okay, and give advice. You really need somebody in charge of a countywide education program, and you need somebody doing really outstanding record keeping and information base IT work. And we think that those things are the one-stop transparency idea, which we proposed, and the educational program. We think combined are more important than the enforcement part, because the enforcement part, some of it belongs to the state, some of it belongs to the U.S. attorney, some of it belongs to the prosecutor, maybe even the sheriff. So the enforcement thing will be narrow. It won't be the main thing, but the teeth must be there for the employees. The employees need to see that there's teeth locally. They don't need to think it's way over there in Columbus.
Well, let me real quick, Mr. Miller, and then I think where we're going. I'm meeting next Wednesday with the State Inspector General in Columbus, and I'll have to check my calendar to see when I'm meeting with Mr. Fitzgerald on this issue. And maybe what we should do is have the county's Inspector General make an introduction first of all, and then also kind of a discussion as to what she views her role to help us guide this policy. Because we're going to have to, in order for us to present an ethics ordinance, we didn't know who the enforcement entity is going to be. Is it an ethics board or not the enforcement, the investigative authority? Is it going to be an ethics board or is it going to be the Inspector General? So
I don't see why the two can't be combined.
Okay. Well, let me do this, Mr. Nani. If you can make a note to see if we can have the county's Inspector General come before us. I'm not sure when she starts full time. I'll report back from Columbus on my meeting, and also report back on my meeting with Mr. Fitzgerald on clarity between on this issue. But it's something we need to think of, because we can't close this ethics ordinance unless we understand who's going to investigate.
Mr. Chair, so we'd have that in one of the work sessions, because I've been trying to schedule each one of the appointees from the executive for one of our work sessions to come in and just give an overview of what they're going to do. So
sure, we can move that.
Put that on whenever the next item, we can have the person on Tuesday at 4.
Mr. Miller.
Mr. Chairman, to Ms. Mayor, I was very much interested in your comment about the Inspector General and the Ethics Board being combined, and I would appreciate your comment on how you might envision that would be structured.
Now I'm speaking off the top of my head, because I think there needs to be a board, and I think there needs to be an enforcement person who could be the Inspector General. Ms. Bird, who's going to hold that job, might herself or might have somebody in her staff under her who could have that specific duty so that's a possibility. If the possibility is that you could appoint the board in a method, I like ours, but you might like something more pointedly bipartisan. Appoint the board and put them in charge of hiring their enforcement officer. But that board might hire Ms. Bird. I don't know how that could work. That's coming off the top of my head. I don't know how firm the connection is between the current Office of Inspector General and the executive branch. Right now, it's a clear one-on-one appointment. But there could be, by this ordinance that you're writing now, it could designate a board, and it could designate that the Inspector General could serve in this capacity I don't know. I'm stumbling over words. I thought maybe I could wing something there, but I'm not doing a good job.
Yeah, this is not something obviously we're going to be deciding today. I just want to throw it out to the board that we need to think about the integration of these functions.
I'd like to just say an anecdote. When we began our deliberations, the work group, everybody wanted to talk about ethics board. It was the hot button issue that took us off task every meeting. So we finally decided we have to declare this subject off limits, and we have to write our code of behavior first, and then find out if we're going to add on to state law, if we're going to add provisions that need local enforcement, then we're going to need an ethics board. So we deliberately set it aside, and we wrote our code of behavior, conflict of interest. That fourth article in our code is really important too. It's filled with a new registry, ideas for registry, and that's where you find our whistleblower statute, which we think is terrifically important. And we also establish an internal ethics committee with an employee from every department that's part of an internal control, so that we're looking for culture change here. A whole culture change. You can't do it with a dinky, we didn't think we could do it with a dinky ordinance that just reiterated state law.
Absolutely. No, thank you for your testimony here today. And I agree with that. I mean, the ethics ordinance is one thing. If there's nobody to enforce it, as we've seen, the last couple of years, it's just that. It's just words on paper. Mr. Miller?
Mr. Chairman, while we're talking about the integration of functions, I would mention that the law department, the prosecutor, the human resources commission, as well as the ethics board and the inspector general, all could have some role in this, and so we're going to have to figure out how these pieces are all going to work together.
No, I agree. And the reason I put this on to discuss had to do with the fact, as we're going through this ordinance and I was crafting the language in such a way, a lot of these provisions refer to someone to report an incident to, or suggest a comment to. So it was always the two. Who do we go to here? So keep this in your mind. Between the various roles, we'll have the inspector general come speak to council as to what their role is, or what they perceive their role is. I'll keep you updated on my conversations with the state inspector general's office and Executive Fitzgerald on this topic. But I just want to bring this forward. I've got another item, but before I monopolize my time on items, does anyone else? I look at Councilman Miller's piece of paper. He's got some other items I believe he may want to discuss, or at least bring up for consideration today.
Mr. Chairman, we've actually been discussing some of the most important of them, but I think one important thing we should consider somewhat structurally is whether we're going to restate state law in great detail, or whether we're going to state the essential elements of state law and then cite the code sections for further detail, which is kind of what the transition group did in their approach, or whether we're simply going to say all of state law is incorporated by reference, but we add the following. So I give some thought to that structurally as to how we're going to do that.
Okay, very good. Thank you. Any comments on that point?
Mr. Chair?
Ms. Simon?
Yes, I believe, I just think going forward structurally as well as analytically, the process, and I agree with Linda, I just think we need to proceed how I would like to proceed, at least, and you're the chair, but go from just our state law and go through it like we've been doing and decide what, if anything, we want to enhance in a particular section. And if we decide we want to enhance, then, the question is, how is that going to be incorporated into our ethics code? And then we can talk about part 2, which I think this is your plan, then talk about enforcement and how is that going to relate to the IG. So, right, are we going to just totally reprint state code and add our enhancements, or is it going to be a whole new structure, as Councilman Miller just suggested? So I think we're all on the same page with this, I think, with the process, correct?
I believe we are. And my initial feeling is, in the way that this is structured, where possible, it takes state law verbatim for us to enhance. We may want to consider, from a human resource perspective, to follow the theme of the Transition Advisor Group, and some of their suggestions is have a companion document, which is more plain speak for the county employees to understand. But at the same time, we have to be mindful that this is an ordinance, this is law, and ambiguity we need to minimize as best we can. And if state law, with our enhancements where possible, is the best foundation for our ordinance, then I believe we should go from there. And we can, as I said, have a companion document which is more understandable to those of us who are not lawyers.
Cliff notes, or I envision, which this is sort of a joke, ethics for dummies, the yellow book. Yeah, so for sure, which will be part of the training. Whoever's going to do the training will have some easier to understand booklet.
Okay, very good. Mr. Miller, do you have any other items on your list now? Mr. Brady?
No, Mr. Chairman, I'm fascinated with the discussion, though. It seems like every time we raise an issue, it just raises more questions in my mind than rather than resolve any. And I guess that's kind of the nature of this particular challenge.
Very good. I have one item. Ms. Conley, do you have any? Ms. Simon? One item, and and I'll reference Mr. Fitzgerald's email that he sent out last Friday. And as far as enforcing 124.57, which is the partisan political activities. And I believe in that email he also asked all county employees that hold partisan, whether it be elected officials or appointed office, just to note that to the Human Resource Department. I believe that was one of the provisions in his email. I wanted to get consensus from this committee. Is that something we would want to, we obviously would find out legally if we can, just ask that information be provided to the Human Resource or the Inspector General's office. I'm inclined to add that if legally we can. Is there any discussion on that? So basically what we're saying is if you hold a nonpartisan office or you're a partisan office, well, actually you couldn't hold a partisan office. If you hold a nonpartisan elected office or appointed office, you just notify the county that you hold such a position. Can we do that?
You might have some freedom of speech. I don't know. I have to look at it. You might have some freedom of speech issues. I just don't know. I do know this, that I commented to some of you earlier, the item that Mr. Fitzgerald is now enforcing was in the personnel manual that was adopted by the county like last October. And every county employee has already signed off on that. So I find it hard for people to say they don't understand that because they'd already signed off. They'd already signed off on that. I know Mr. Nani was involved in creating that code.
It's important to note that all Board of County Commissioner employees signed off on that policy manual. All the other entities that came under the fold of Ed Fitzgerald, I couldn't tell you for sure whether or not that was something that the elected officials at the time passed on to those employees. Probably not.
But your question, Mr. Greenspan, is could we require every county employee to reveal whether or not they're a member of a nonpartisan board? Now, I know in my conversation with Mr. Morales, and he and I were doing some fairly extensive legal research on that on Friday, that you cannot prohibit a person. Supreme Court has been quite clear on that. You cannot prohibit a person from the nonpartisan activity. So your question is the next step. Can you ask them to reveal that? I don't know. We'd have to take a look at that.
That was my question. I wish Mr. Morales was here. Yes, Mr. Miller.
I would bring to your attention that that similar recommendations are in the transition recommendations, and the question is where the reporting is done to. What the transition report says under secondary employment is they say, no covered persons compensated by the county shall engage in secondary employment if that employment is incompatible with the proper discharge of official county duties or might impair objectivity or independent judgment on the job. This includes elective office in another jurisdiction or in a political party. So it's not limited to the political party area, but it's more broadly covering the possibility of a conflict between the secondary employment and one's county duties, which could arise from a number of reasons.
Right.
And then it goes on to say, all covered persons shall disclose secondary employment in writing to the Human Resources Department and to the County Ethics Board on an official form approved by the County Ethics Board, updating this information wherever it changes. That's what the transition.
Serving on a board may not come under the definition of employment. I have to look and see what the definition of employment is.
Yeah.
Very weighty legal issues here. We have to just spend some time on this with the law department.
Yeah, that's what I was hoping Mr. Morales would be here to discuss this, but I'll bring this point up with him. It's just disclosure. That issue had to do with employment of people receiving compensation. What I'm asking is more broad than that. And obviously, what we're talking about here will need to be vetted legally, and both here and in Columbus. So I just throw that out there as something to consider. And I'll do some more background. If Mr. Morales was here, I was hoping he'd be able to give us a more definitive answer.
Mr. Chairman, I think as an alternative, we might require that the disclosure be made to the Human Resources Department, and then the Human Resources Department might be empowered to decide when a particular piece of information needs to go to the Inspector General, as opposed to having everybody send this kind of personal information directly to the Inspector General's office.
My only counterpoint to that would be is if the Human Resource Director is an appointee of the executive, then they're not truly independent to be able to weigh in as I would hope an Inspector General would be independent. That's just my only comment on that. Mr. Brady?
Mr. Chairman, just to be a little clearer from where the conversation started, I think, you had brought up the directive that Ed Fitzgerald the executive had sent out to the employees, and then you were asking if you thought we should take some kind of action or add something to what we're doing to, and my question then, Mr. Chairman, is if the county executive has sent out a directive to his employees, why is it that we need to do something as well?
Now, this would just be, and I appreciate that comment, this would be, my question was, is this something we wanted to include in the ethics ordinance, that the employees disclose this information as a part of the ethics ordinance?
Yeah, and what does it add if it's already in state law, if it's already been, and it's already being enforced by the county executive? What are we trying to achieve?
I don't believe that the asking as I'm proposing is in state law. 12457 says it's prohibited activity. You cannot hold a county office and be in a partisan position. What I'm saying is open it across the board to all employees of the county. Just notify. Obviously, they're not going to be able to be employees and be in partisan activity. That's being enforced. What I'm saying is, if you were in a non partisan position, should you declare that you have that position? If someone is a city councilman in a city that's nonpartisan, should the county be aware of that activity? That's my only statement.
Mr. Chair, May I?
Ms. Simon?
This only applies, as we have it in front of us, to classified employees, correct? So why would we consider having non-classified employees have to report to the executive about that activity?
It's not per se reporting to the, it's just reporting to the county, whoever within the county would hear it. Just so the county has knowledge as to who, not that anything will be done with it. Should the, I mean, I ask, should the county have knowledge if someone is a member of a nonpartisan municipal body?
But here's my question. My understanding of the charter is that the county executive has all control over employees. Do we have the authority then to direct those employees to do anything? I thought that, okay, Mr. Nani, can you correct me?
One thing I just want to bring to your attention, I don't know if this is exactly what you're talking about, but in the current ethics code that is in the policy manual, section 3.04 talks about a moonlighting policy. And it says the county does not prohibit an employee from securing additional employment outside their employment with the county so long as the following conditions are met. Number one, the employee provides notice of their outside employee to Human Resources prior to beginning work with the second employer. The employee's outside employment does not interfere in any way with the ability to perform the duties. The employee's outside employment does not place an employee in violation of the county's code of ethics, then section 3, including but not limited to creation of a conflict of interest.
But I'm a non-paying, I'm a member of the library board of some nonpartisan city. Is that employment within the meaning of the legal definition? I don't know. I don't think so.
So, Mr. Nani, let me ask the question. My question might be answered in your answer. Then what you're saying is it is current county policy now for employees that sit on municipal city councils, because it's a secondary employment, to have already notified the county that they do so.
That would be my reading if you believe that an paid elected position is.
But I'm an
secondary
unpaid
employment.
position.
Unpaid is
I don't
another
think
story.
I don't think it's employment within the meaning of the definition, the legal definition of employment. I don't think you can force them.
Okay. Well,
I'm a member of a non-paying more of a library. I meet once or twice a month in the evening. It has no effect on my employment with the county. I work during the day. I'm not called to work in the evening. I don't think you can force them. I mean, I don't know who would really care to argue it, but if somebody argued, I don't think you can force them.
then my question was answered by the current moonlighting policy. That's all I was getting at. So if it's already current policy, then there's no further discussion. It is what it is. Okay. Thank you. All right, if there are any other items for this meeting, then before I begin, then what I'll do is continue on the same path. You have the ordinance through sections 1 through 4 in front of you. Please review it. I'd like to meet again next Tuesday at 1 p.m. That should work. Next Tuesday at 1 p.m.
We have a work session at 4, but we don't have a meeting.
And then we will work through these items, and as soon as I can get the rest of the ethics ordinance compiled, I will submit that to you. Depending on how quickly that happens, we'll include that in the meeting for next week. But at least let's review these first 4 articles for next week, and I will include the definitions and send another copy out to you. So there's one document we're working from. All right. If there are no other items before this committee, I'll take a motion to adjourn. Second. All right, this meeting's adjourned until Tuesday at 1 p.m. Thank you.